There are two kinds of legal divorce: a divorce that doesn't end up in court and a divorce that does. If you're facing the difficult choice to end a marriage, it's wise to do your research so you understand both options. This can help you to make the best choice for your circumstances. Let's cover both kinds of divorces and the different paths of each. When you're done watching, eForms has downloadable documents that can make the financial and legal parts of the separation more manageable. You've got a lot on your plate already if you're dealing with the emotional parts. The link below this video will take you to some of our fillable agreements that can guide you through the process of getting a legal divorce. First, let's cover uncontested divorces. This is when spouses separate amicably. They agree to evenly divide the assets they have acquired during their life together. They agree about who's getting child support and how much, who's paying alimony, payments to a spouse after a divorce, and how much, and who's getting the house. They file paperwork with a county clerk's office that includes information like their names, dates, requests, and the grounds for the divorce. They outline the terms of their divorce in a settlement agreement. A judge will review the agreement to be sure that it doesn't violate any laws, and then approve it. In some states, the whole process can be completed through the mail. In others, one spouse has to show up to court. In others, both spouses have to show up to court once. The divorce can be done in a few months and doesn't require lawyers. If you don't hire a lawyer, your only expense is the filing fee, which varies by state and county. While an uncontested divorce might sound like the most hassle-free option, it's worth noting that agreements you make now lack legal teeth, so to speak. Now, what is a contested divorce? A contested divorce is a lot more complicated and a lot more expensive. When a couple can't agree about how to divide the kids and the money, the court decides for them. There are various reasons this may seem like a couple's only option. You probably know people who have chosen to undergo the process of a contested divorce. One partner might feel the other was responsible for incurring all shared debt and argue that it's unfair to divide the debt evenly. Or a spouse might feel that she shouldn't have to pay alimony because she already supported her husband financially throughout the marriage. One parent might protest sharing custody, believing he is a better, more stable parent. Contested divorce hearings can last for months and require many court appearances. A contested divorce can cost anywhere from $20,000 to $100,000. In a contested divorce, a judge decides division of assets and ongoing arrangements. Depending on the state, the court will either observe community property law or equitable distribution law. The first refers generally to a 50-50 division of assets. The later prioritizes fairness over equality. The upside of a contested divorce, which is difficult and costs a lot of money, is that the final court order records the agreement in writing. Every marriage is different. Only you, your spouse, and your trusted advisors will be able to make that choice for you. Whatever you decide, you can begin the process by clicking the link to access a fillable template for a marital settlement agreement.